go to district court.
Can I just ask you, because it seems to me that the thing that is bugging me about this, your argument, is that we could look at the statute that's here and discern that Congress intended to allow the agency to do its work and then have judicial review. Not so much, exactly the nature of the claims that can be brought, but at a minimum, the fact that the statute requires the Court of Appeals to wait in general before it gets involved. You have to have a person who's been aggrieved by a final order of the Commission before the Court of Appeals gets involved. Makes me wonder whether Congress really intended for 1331 to be operating to allow the district court to be issuing and considering interlocutory arguments by parties, whether they're the kind that you're making, this entire thing is unconstitutional, or other things, discovery, whatever. I'm worried about a notion that 1331 can be used here to undermine congressional intent about the finality of agency action before the courts come in.
Sure. So we don't think that there's anything in 78Y, the SEC Act, which indicates an intention to displace district court jurisdiction over the structural constitutional claims at issue here. Now, you're right. Congress made clear that it wanted challenges to final orders to go to the courts of appeals. But another thing that's, I think, relevant to the question here is that in describing what the courts of appeals could do, it said it could set aside or modify an order on the record that had been developed. And I think that that's pertinent to the question here, because that doesn't really give us the relief that we're looking for, which is an injunction against proceeding before unconstitutional
I understand,
ALJs.
but my question is, can we fairly discern that it was Congress's intention to allow for that kind of interlocutory argument to be made? Or was it saying, I mean, I agree with you, there's nothing that suggests that that argument can't be made at all, but can we fairly look at the language here and say that Congress intended for that kind of argument to be made while the proceedings were going on? And I think it matters. I mean, one of the things that your colleague on the other side pointed out is that maybe there was a reason why Congress would have wanted that to be made later, in part because it may avoid having to have judicial review at all. And traditionally, our thought has been you don't jump in to decide constitutional questions, and if there's a way to avoid it, you do. So it seems rational to me that when Congress was putting off even Court of Appeals review in this case, it was saying anything that you have related to the sort of constitutional nature of this, wait until the agency finishes, and then everything can be brought at that time.
Right. So I think that set of concerns is different, Your Honor, in the sense that we are suffering what this court has called a here and now injury by simply having to proceed before an ALJ that is unconstitutional in its very existence.
But that assumes the merits. That assumes the merits, right?
Well, what it does, it looks to the particular kind of claim here. Of course, you're right. We have to actually prove that the removal restrictions are unconstitutional. But it's what distinguishes this structural constitutional claim from the sorts of preliminary orders that you might see in an ALJ proceeding, which don't actually aggrieve one until they're embodied in a order of the Commission, which at that point in time you can challenge to the Court of Appeals and get the relief you're asking for by having the Court of Appeals set aside that order. That's not true here, both because we're suffering this injury wholly apart from whether or not we win or lose at the end of the day for the agency.
Why isn't that any single person who has the type of claim that would challenge the agency review in a similar way? I mean, we've heard some of the other examples of types of claims, and I'm just wondering, why couldn't anybody make the argument, similar to the way Justice Kagan brought up some examples, those arguments sort of challenge the unconstitutional functioning of the agency?
Well, I think most of the arguments that would come up tend to involve the particular facts and circumstances of the individual proceeding. The structural constitutional claims are different. They're not related in any way to the facts or circumstances of given proceeding. They go to the inherent nature, existence of the decision maker. And I think that's an important, I'm sorry, Your Honor.
No, please.
I was going to say, I think that's a very important distinction that this court has drawn, for example, in the Carr versus Saul case.